All right. Our next speaker is Linda O'Brien, a key member of our group at Yellowknick Ellis Gluckstein. With nearly 30 years experience in civil litigation, she previously defended tort litigants, but now advocates exclusively for survivors of sexual abuse. Linda has appeared before all levels of Ontario's courts and has spoken at numerous legal events. Today, she will share her insights on the role of the civil justice system for survivors. Please welcome Linda.
That one? Okay. Can you hear me? Okay. So I was about to say it's a double whammy because you have me right before lunch. On a positive note, it's only 15 minutes. And it will be the most boring topic that you have to listen to today. So I'll do it quickly and get it over with fast so you can eat before we have more interesting speakers this afternoon. What is a civil lawsuit? Let's start with what it's not. It's not a criminal case. And Emily spoke very eloquently earlier about what a criminal case is and all of the inherent flaws in our justice system. Typically, when somebody comes to us or to any other lawyer for advice following a sexual abuse, historical sexual abuse, we always ask them and tell them about what their options are. And the first option is obviously you can report it to the police. And if you do that, that's fine. We'll wait until all of the criminal process is over before we actually implement a civil lawsuit. The reason for that is because if you start a civil lawsuit while you're in the process of a criminal lawsuit, you can bet that you are going to get cross-examined by the defense lawyer on the fact you're only doing this for money. And it's, quite a traumatic line of questioning. It's used all the time. And we have been doing some work with a group of Crown attorneys to try and deal with that whole issue and line of questioning to begin with. So to avoid that situation, we generally do not start a civil lawsuit until after a criminal process has been completed, if it's going to be completed. The difference between civil and criminal also relates to the fact that when you do go and report the crime to the police will investigate. They will take the results of their investigation to the Crown, and Crown will determine whether or not they'll lay charges. You, after providing your initial report and initial statement, are not involved in the process anymore. It's not a case of you versus them. It's a case of the Crown versus the accused. When you do a civil lawsuit, the civil lawsuit is you versus the perpetrator. It is a situation where the perpetrator is not going to go to jail as a result of a civil lawsuit. The main remedy that you obtain from a civil lawsuit is money. I mean, it's as straightforward as that. Some people will ask for apologies, but apologies are not something that can be ordered. Nor would anyone really want one, because if it's ordered, it's not genuine. So the whole purpose of a civil lawsuit is money. You have less of a burden than you do in a criminal lawsuit. In a criminal case, the Crown has to prove that what happened was beyond a reasonable doubt. It's quite a high burden. In a civil lawsuit, it's a balance of probabilities, so 51% chance that it happened versus didn't happen. Let's talk about who can be sued, and you'll notice I'm not using the PowerPoint because I just will not be able to coordinate everything. So who can be sued is obviously the perpetrator, but a lot of the work that we do in particular is historical, so often the perpetrators are long since deceased. You can sue the institution if there was an institution involved, like the CAS, schools, church, sports organizations, and you can sue in a civil lawsuit anyone that knew what was going on or should have known what was going on. So often family members, anybody else that had a really good idea about what was happening and didn't do anything. Why would you do that? So when you consider civil litigation, the last thing on earth that any, well, hopefully any lawyer wants to drag you through is the process if there's nothing for you to accomplish at the end. So the only thing you can receive is money, which means we want to make sure at the front end that there's money to be had. If it's an institution, it's not going to be a problem. But if it's an individual perpetrator, it's a big problem. It's a big problem if they don't have anything, they don't have a job, any of those things. Because to take you through what could be up to 5 years of litigation in the civil system, because if you think that criminal courts are slow, civil goes after anything criminal. So when there's criminal matters to be heard, because of that Jordan rule that Emily talked about earlier, the criminal matters always take precedent over any civil matter in court. So civil matters go on for a really long time, and they're very invasive in terms of looking at all of your records, all of your history, and there's no point in taking you through that process if there's nothing for you to obtain at the very end of that process. It would be not only re-traumatizing, but actually probably quite horrific for you to go through that, or for any of your clients to go through that. So the people will ask, like, if there's nobody to sue, you'll look at all of these different options, and one of them is, like I mentioned, which is, was there anybody that knew or should have known? Because if, for example, it was occurring in somebody's private home, then we can sue those people, and hopefully they have a home insurance policy that may be able to respond to the lawsuit. There's issues with that, but if it can respond, then there's something there. If they own the home, then there's probably equity in the home, so there's a reason to go after that. So that's why I talk about those other individuals. We try to find all the different pockets of where there might be something to pick, in the sense that we want to make sure that a survivor can obtain justice from the process. Is it easy? In some ways it is. I mean, if you go the criminal route and you have a criminal conviction at the end against that perpetrator, then it makes the civil process more about just talking how much do they owe you, as opposed to fighting over whether it happened, didn't happen. It can be easier if the perpetrator is actually deceased, because then you're not facing that person, particularly if the thought of facing that person is going to be extremely traumatic for you. It's also easy if you have a fairly clear pre-abuse history in terms of what your life was like. And the reason I mention that is because in order to compensate you with money, it's based on a thing called damages, and damages are what can be provided to you. So how have you been damaged? Have you been damaged in terms of your pain and suffering? Have you been damaged in terms of economic losses? Have you been damaged in terms of the ability to form other relationships? So I mentioned earlier that civil litigation is very invasive. So that's the not so easy part of it. What happens is, if you come in to a lawyer to talk about what you can do, you'll learn that you're going to have to produce and basically every single document that you've ever had generated on your behalf in your life. So they're going to start at day one of your life, and they're going to carry you through to the present time. And I'm talking about the defense lawyer on the other side, which means we're going to be getting all school records, all tax returns, all employment records, all medical records, all therapy records, full CAS file if that was relevant. So all of those things are open for the other side to look at, to analyze, to strategize, and what their goal will be is to pay you as little as they possibly can, whereas the people representing you are going to be looking to get as much as they possibly can for you. So to do that, they will attack all of those different things in your history. So they will look for prior trauma, they'll look for addictions, they'll look for difficulties with relationships. Obviously, so much of those types of things derive from the initial abuse that it makes it, something that we argue that stems from what happened to them, whether it be as a child, whether it be as an adult. So many of those different things occur, and experts end up getting involved and giving opinions on that type of thing so that your damages can be established. I'll talk really quickly about what the steps are in the civil litigation, and these are very broad steps. The first is an intake, which we talked about, where we get a very detailed history of what happened. We start collecting documents, all of your documents. The biggest process you go through is what's called an examination for discovery. And in the examination for discovery, it's an opportunity for the lawyer for the defendant or defendants to ask you questions about your life, what happened. They'll talk to you about the abuse. They'll talk to you about your education. They'll talk to you about your jobs. They'll talk to you about your addictions. They'll talk to you about everything. It's not a cross-examination. It's different than that. It's an examination, so they can't challenge you on those issues like they would in open court. That process allows them to obtain a feel for how you present as a witness. It then enables discussions to happen after the discovery on where things will go next. Typically, things next go to a mediation or other settlement type of conference. If you cannot settle at a mediation, which involves having a neutral third party there to, frankly, carry offers back and forth between the parties, then you go to a pretrial and try once more, but a pretrial is actually in front of a judge, and a judge will provide you with a legal opinion as to what they believe the liability is in terms of who's responsible for what happened and what they believe the damages are, and they will try to resolve the case there. If that doesn't work, your matter goes to a trial, and it's something that doesn't happen very often in civil sexual abuse cases. Most of them, almost all of them, are resolved prior to a trial. But if a trial is required, then that's where everything ends. And at the end of a trial, you will obtain a judgment. So I know I was very quick in talking about a lot of those things. If anybody has any questions, feel free to ask or come and speak to any of us later on, and we can give you a little bit more information about the whole civil litigation process. Oh, sorry.
Just a short question. Why do you...
Thank you. Why do you think that most don't go to trial? I understand that there's lots involved, but what if someone wants to go to a trial to raise awareness?
So a civil trial is not necessarily going to raise much of any awareness just because of the venue for it. The venue for awareness tends to be more of a criminal trial. Most cases don't go to a civil trial because the law is not fully developed in certain areas of responsibility and in certain areas of damages. So it's risky for both sides, and that's the reason why lawyers, along with their clients, whether they're on the defense or the plaintiff side, will try to negotiate a resolution knowing what those risks are. The thing with a trial is you also have to pick the right case to take to a trial, so you have to be very solid on the issue that you want a judicial decision on, because the last thing you want to do in the survivor realm is create a decision that's going to impact like so many survivors, not just the one that's at the trial, but it could have a ripple effect on so many in so many different areas. So that's something that gets discussed towards the, like, if everything's failing before you get to that step.
I just had a brief comment. One thing I think does help is, and this is notwithstanding the effect that this can have on victims, and obviously the victim's health and well-being should come first, but notwithstanding that, if the victims are able, I think it is a good thing to sue institutions, because what I saw from working inside government is that when institutions are getting sued and getting sued in bigger numbers, that does drive change and reform. And so ultimately, that's why I decided to sue the institution, because it was the only way that they can be forced to hear what they're responsible for, and you can force change that way. And governments do respond when they suddenly see the liabilities piling up. So for those of us who want to drive change and can stomach civil litigation, I do think it can help push reform in the long term.
That's definitely true. Because money talks, right? And the more certain institutions are hit with the money aspect of it, the more they might work to change. One of those areas right now that we're working within is the child welfare system, which is the most broken system that exists. And the only thing that's going to help is the more times the government has to become involved in these lawsuits, the more money they have to spend. Maybe somebody will then start paying attention to the fact that, we have children that are being horrendously abused in care and dying in care.
Yeah, and their insurers should be helping too.
Sometimes there usually is insurers, but sometimes they're uninsured. Yeah. So, okay. Thank you.